Hello and welcome to the fifth video of your course on legal writing. In this video, we will learn some methods of using legal research in your writing. Since we are going to pick this up from where we left off in the last video, we will continue using the same research question to help us talk about these methods. The question we used in the last video was: outline the key differences between a company limited by shares and a company incorporated with unlimited liability. Now, we will start this video at a stage where, in response to this question, you have already found some secondary sources and perhaps even some primary sources. You now need to think about how you are going to use and present those sources in your writing. Remember that when we learned previously about the writing process, we spoke of the structure of paragraphs. Yes, I'm referring to the IRAC method: issue, rule, analysis or application, and conclusion. So in which part of a paragraph will you use these sources of law? Obviously, the rule and application parts. Those are the parts of your paragraphs in which your primary and secondary sources of law will feature. The sources of law will tell you what the rule is, how the rule has been applied in the past to various fact situations, and how it has been analyzed by others in the past. Let's start with primary sources. What do primary sources do? They state what the law is. Here are some examples of primary sources: statutes or primary legislation, subordinate legislation such as rules and regulations, and judgments or case law. Now, how do we use primary sources of law in our writing? The first situation we need to understand is one where the general area of law to which your research question belongs is governed by statute or subordinate legislation. How do you use case law in such situations? Case law in such a scenario is used to explain what the words in a particular section of the legislation or subordinate legislation mean and how those words should be applied in practice. So generally speaking, if you are researching on an area governed by primary legislation, then use the case law to enhance the understanding of the statute. But what if there is no statute or delegated legislation governing the particular area that you are researching? Or what if it is not immediately clear from reading the statute or rule whether it applies to your research question? In such scenarios, case law has a far more important role to play. For example, long before there was an Indian Contract Act, there were decisions of the courts of England outlining the basic elements of a contract, such as offer and acceptance, consideration, and the meeting of minds. The contract law was thus purely based on case law, known at that time as common law. So what case law will tell you in such a scenario goes beyond merely explaining the law. The judgments will tell you what the law actually is. It can be used in your writing to fill a gap in the legislation or to bring clarity to some legislation. So that's how you should use primary sources: to understand what the law is and how the law should be applied. And while statutory law and case law can, depending upon the context, serve different purposes, your use of these primary sources should always complement each other. After all, your purpose should be to help the reader understand what the law is and how it should be applied. And that should be the purpose to which you employ the primary sources in your writing. In response to your current research question, you would probably come across provisions of the Companies Act, notification from the Ministry of Company Affairs, and judgments from some high courts. You may come across a provision in the Companies Act that you find is directly applicable to an issue that is relevant to this question. In that case, your writing should rely more on the provision. On another issue, you may find that the Companies Act is silent, but that a high court has discussed it in a judgment. In such a case, rely more on the judgment. In both cases, use these primary sources to provide a clearer understanding of what the law is. Now coming to secondary sources. Good textbooks and commentaries are immensely useful when it comes to explaining what the law is and how it should be applied. They will help you understand what the primary sources say and what the law is and how it should be applied. So when you are explaining an area of law, use secondary sources. Now, secondary sources are also important because they will give you ideas on how to analyze and critique the law. This you will mostly find in journal articles and the opinion pieces in newspapers, magazines, and some web-based sources. They will often point out inadequacies in the law, or how a new piece of legislation or a new judgment has improved the law on a particular issue. You may even find analysis that will take your research to the next level. For example, in this case, you may find newspaper articles that have discussed problems with the implementing of the 2013 company law. One thing you need to be very careful about is that when you are using someone else's ideas, you need to attribute them properly. So go through the reading material to learn how to cite someone else's ideas and how to provide references for your research. While there is nothing wrong with using another person's ideas and discussing them or combining them with your own research and ideas, you need to make sure that you are not passing them off as your own. Thank you for watching.